Record in John Worthington versus Westnet. This is cause number 15-025033. Today we're before the court for a motion for default. Mr. Worthington, when we first on the record this morning, requested me to consider recusing myself, making an oral motion for change of venue. Correct? That's where we're at, Mr. Worthington?
Visiting judge or change of venue.
Visiting judge. All right, so I've taken the opportunity to review the rules regarding disqualification or recusal. Based on my review of those rules, I'm going to decline to recuse myself. I have no personal bias or prejudice against either party. I have no personal or family connection with the party. And I will do my job and fairly and impartially apply the law. So I am, at this point, not going to recuse myself. As it relates to an oral motion to change venue or have a visiting judge, first, I think that motion needs to be properly briefed and noted before the court. And second, I'm not sure this court has jurisdiction yet to issue a decision on a motion due to the underlying issue that I had started to discuss with you earlier regarding service. Okay?
Your Honor, Is there a motion before you right now challenging the service?
In order
Are you proceeding on behalf of parties when you determine that they have or have not been served? Wouldn't it be appropriate to either sign or decline the order and let those parties argue whether or not they were properly served? Or
in order for this court or any court to issue a default, which is the request before the court today, the court has to have jurisdiction. The court doesn't have jurisdiction unless service is proper. So it is proper for the court to determine whether or not service has been properly accomplished. Okay? So that's where you and I think are at a disconnect right now. I'm trying to explain to you that I don't believe service is proper.
But it was in the Westnet case on the public records, which they argued there was no difference. You're saying that there is a difference.
And I'm happy to explain it to you if you would like me to.
Sure.
So, all right. You have, by your information today, and specifically your supplemental declaration in support of your default judgment, you have brought in to this case the other two cases before, indicating that prior service was proper under those two cases based upon service upon, I think it was the Kitsap County Sheriff's Office, and they were personally served. What I tried to explain at the beginning, Mr. Worthington, is that the difference in these two cases is that the first case was based on a public records request. And based on the case that you and I did, which was cause number, I think, 11-2-026983, we know that there's an interlocal agreement, and the interlocal agreement includes a group of agencies, member agencies in Kitsap County, which does include the Kitsap County Sheriff's Department. Through your investigation and your process last time, you were able to determine that the Kitsap County Sheriff's Department was the record keeper for the public records.
I was able to determine?
According to what we did before, that's what it appeared to me. And so service was deemed proper. I was not the judge that did service. I believe that was my predecessor, Judge Short. But service was deemed proper, but the request before the court was a complaint based on public records. Okay? This seems to be a broader complaint that you're asking from the court. Okay? It's not specified or confined to the rules regarding the public records request. It's a more general civil complaint. Correct? That's what it appears to be. So I want to make it clear for the record, for both you and myself, that the merits I'm not considering of your complaint today. All I am considering is what the service is. And so you have served an employee of the Kitsap County Sheriff's Department, okay? The Sheriff's Department is a department of Kitsap County. So service of your complaint should have occurred on Kitsap County, and by statute, service on Kitsap County has to occur via the auditor's office. So that's the first issue. The second issue is that what you're asking for the court to do is to grant relief that would affect all of the agencies that are part of the interlocal agreement. So each of those agencies needs to be served in order to proceed forward and bring all parties before the court and give the court jurisdiction to proceed. So today, I'm not granting your motion, but I'm denying it without prejudice. So you, as long as you serve the appropriate parties and bring all the people that need to be before the court, you can proceed on your motion for default as long as there's not a proper answer filed. If there's an answer filed, then the case can proceed as it normally would under a civil case. But I have to have all of the parties properly before the court has jurisdiction to grant or really deny the merits of your complaint. I can't get to the merits until I have service, because service gives me jurisdiction, is essentially what I'm saying. Does that make sense?
It does not. It makes sense, but I object because the question that you're relying on and the basis you're relying on has already been briefed. The third base coaches are over there. I'm going to point to them. I'm not going to look at them, but why they're here, I have no idea. It just kind of underscores this we're here, we're not here type of thing. You've made an error in your assumption that this court does not collect money. This court does collect Westnet money, and you put it in a Fund F. So as long as the Kitsap County Superior Court collects millions of dollars and puts it in a Fund F, if you were to sign this order for me today in my favor, I could put a lien on Fund F. Because you've established a fund, and it's not a Kitsap County fund, it's not a Washington State fund, it's not a Port Orchard, Paulsville, it's a Fund F. So you do collect money for Westnet. So what you're saying is, basically, whether you know it or not, and I'm giving you a chance to clear this up, is that this court is laundering money for Westnet in Fund F. Because you're collecting money for an entity you're admitting and ruling doesn't exist. And you're holding that money, and then you're not sending it out to the state, to the member agencies. You're putting it in a Fund F. You're not even putting it in a Westnet fund. You're putting it in a Fund F. So this court is up to its neck in this Westnet thing. I do believe you have a serious conflict of interest here. You as a judge, because one court judge makes a ruling that's kind of bound by it, the other judges are bound by it. You're basically all the judges right now as you sit here. The way I see it, all the judges have a serious conflict of interest because of Fund F. You collect money from the people in your court documents as Westnet. You were under the impression, the wrong impression, that this court was not collecting that money, but you are. And it's the fact that you're collecting it in a Fund F and not as a Kitsap County fund that undermines your argument in your previous case that Westnet doesn't exist and that everything's done under the Kitsap County umbrella. Do you remember that ruling that you made where everything's done under the umbrella of Kitsap County? If that's so, then why are they collecting money under a Fund F and using Westnet, telling the people to pay money to Westnet? And so I think at this point, the court should sign the order or deny the order for whatever reason, and let the jurisdictions argue whether or not it was proper service and yada yada. That's how the default judgments that I have been involved with, they work, they have a right to dispute the default judgment, Westnet, and that's how they would dispute it. They would say, we don't exist. And of course, I would argue, well, you've written 200 plus checks to Westnet, you showed up, you know the argument. And the third base coaches over there, they know the argument. I don't know why they're here.
I'm not aware either, Mr. Worthington. And I understand, I think, what you're saying, but you're not there yet. You have to get all the parties before the court can proceed. What you're saying is, I should grant or deny the default based on having all the parties properly before the court, but you're not there. The court, you have to have service upon all of the parties, and it has to be proper service before all of those parties are before the court. Then if they choose not to appear, and I'm granting leave to continue your motion for default. If they choose not to appear and your motion for default is brought back before the court, then it's very likely that the court will authorize your motion for default. And then the parties can come back and make those arguments that you're indicating now. What I'm saying to you is the court doesn't have jurisdiction to grant or deny your default based on the merits of the case if I don't have jurisdiction to proceed. And I don't have jurisdiction to proceed unless there's proper service on all of the parties. This action is a little different than your prior action because this is not a public records request action. So service is different. I understand that.
They said that there's no difference between them. That issue's kind of been decided. What you're saying is that you're not accepting this because Westnet doesn't exist, while the court collects money for Westnet, which is the basis of the complaint.
What I'm saying, Mr. Worthington, is I'm denying it without prejudice today because service has not been properly completed on all of the agencies that it would be required to be completed on. And that's all I'm saying today.
Well,
I'm not touching on the merits of the case.
You have to say more than that because Judge Lori already accepted service on Westnet and she heard it.
Under a different cause number and a different case. You have filed a new action, and when there's a new action, service has to be done appropriately on a new action. That's all I'm saying, is that service isn't complete, and until service is complete, the court doesn't have jurisdiction to move forward under this cause number. That's all the court is saying. So, I understand that.
You're taking money for Westnet, and you have a huge conflict of interest. You're collecting money for Fund F,
and I don't know any of that to be true. I don't, the court doesn't collect. We sign orders presented to us. But I'm not going to get into that with you because, as I indicated, the issue today is whether or not service is proper and the court has jurisdiction. That's all I'm saying today is service is not proper, and so the court doesn't have jurisdiction to proceed on your motion today, which is a motion for default on the underlying complaint. So that's all we're doing today, and the hearing is concluded. We're at recess.
All rise.
Just keep changing the rules. That's all we have to do. Keep changing the rules and you'll never get there. Pretty much for this caption.
Right on, guys.
Good job.
She's deciding they don't exist. Because she can't just say service is improper without deciding whether or not they exist. So she decided whether or not they existed, and that's the basis of the
I'm gonna
complaint.
ask you guys
She's trying to make it seem like the only decision that she's making is whether or not there was proper service. But to make that decision, she had to rule, basically, without officially ruling that Westnet doesn't exist. So how does she get there without admitting? You heard her She said the only thing she was deciding was whether or not there was proper service.
Meaning all parties have to be
Yeah.
in the courtroom for her to make a decision, or she has to hear all parties, is that what she meant?
Yeah, she basically, even though in the other case, what she's doing is preventing, then it changes the context of the ruling that I'm after. If I'm up against the affiliates, it removes the question of whether or not Westnet exists or not. So what she did there was force it into the realm of the affiliates so that I couldn't get an answer on whether or not Westnet exists legally. That's why she did it.
Jurisdiction, she's claiming she first has to determine if she has jurisdiction. Jurisdiction is a statutory function. It's governed by statute. The statute is 4 point something. I'll give it to you. And the way the statute reads is if jurisdiction is challenged, then it becomes a triable issue. What she's doing is not even recognizing that who's challenging it at this point.
Exactly, that was a good argument.
Except the judge herself.
Are you arguing for them?
Yes.
That was a good point. The judge was arguing for them without them being here to argue.
Yeah.
She should have made a ruling. You had an entity, you had a fund that you could attach that would have forced the rats out of their holes, you know? And she is arguing against that so that the rats could stay hidden and you can't attach that money.
But they create more and more and more legal fees.
Well, that's the thing.
And this has been 10 years now.
Yeah.
In order to, you're gonna give up before you win.
Yeah.
It's no skin off.
There's a few of us that don't.
It's like finding Dr. Livingston. I'm still looking for him, you know.
Yeah.
I'm never gonna find him.
Since there is a statutory.
Thanks, Jeff. Thanks for coming in.
All right,
Appreciate it.
pleasure. All right,
Thanks for holding on.
You're welcome.
Okay.
Nice meeting you. All right, guys.